Your lawsuit says that she owes you for some rent. She owes you for some damage she did to the property.
Yes, ma'am.
She owes you for property that was destroyed that you brought into the house after she moved out in order to fix up the house. You believe she's responsible for the house being burned to the ground. Ms. Hoskins says that she's not responsible for the house being destroyed, that you and your grandson harassed her and her boyfriend. She's counterclaiming because she says she was forced to move. How did you find her as a tenant?
I have a letter from one of her kin people, from Nadine.
She's not kin to me. She's kin to my sister, not me.
Is this Nadine someone that you knew?
Yes, I've known Nadine since she was a little girl. She's the best friend of my daughter's.
And Nadine told you about Miss Hoskins?
Mm-hmm. She told me that she had a little baby, and her husband was in jail, and she desperately needed somewhere to live.
What's he in prison for?
He's in prison for, he's got numerous, indictments on for firearms.
How long is he in prison for?
5.5 years.
All right, so, Ms. Perkins, when did she start the lease with you?
Okay, got that too.
Questions are going to get harder, Ms. Perkins. I wish you had this information at your fingertips. When she started the lease, when she moved out, because you say that she owes you for rent. You moved in when, Ms. Hoskins?
The beginning of May of 2005.
And when did you move out?
The beginning of March 2006.
She moved out March the 4th.
Okay, and what months do you claim she did not pay rent?
She never paid February's or March. She paid part of January. And I took her to court, and the judge said that she was supposed to pay $140, which she owed me for that, plus the $38 for the court costs.
How much was the rent, $375?
$375 plus late charges on all of them.
Quiet.
Ma'am, we went to court over the $140.
And what happened?
And I got a judgment against me.
So you got a judgment against you.
Yeah.
Did you ever pay her the $140?
No, I haven't got a chance.
All right, fine. So that's $140 and $375 for the month of February. You did live in the house in February, according to you.
Yes,
did you pay her February's rent?
No, I didn't.
Fine. Now, what kind of damage do you allege, Ms. Per, the house?
Okay, this is the damage to the house, the pictures. This is the one from the fire itself.
I don't want to see the fire itself. I want to see the damage to the house. Are you showing me, are you sure you're giving me the right pictures?
Yeah, the ones with the, there's a few holes in the walls. Stove is dented in with no knobs.
Was this before or after the fire?
That was before the fire. But see, I never got any pictures taken because before I could do that...
Were these pictures taken before or after the fire?
After the fire.
Well, that's what I asked you, so just answer my question, because it looks as if they were taken after a fire.
They were taken after the fire to try to pick up parts of the holes and stuff that she had made before the fire.
Okay. Who are you?
Detective Roland Grimm.
Step up, please.
I have an inspection where I called code enforcement on the house. And this is a list of all the things that she had a certain amount of days to fix all the things that were wrong with the house.
Listen to me. If you don't like where you're living, it's a free country. You take your baby and you move out. But you don't stay at the place and not pay rent and complain about it. That's just my idea of America. You don't like where you live? Move. All right, Detective, were you assigned to investigate the fire at this house?
The arson, yes, Your Honor.
Okay, and it was determined to be arson.
Yes, it was.
So tell me what you know.
The problem with this case was that Ms. Perkins only cooperated with the police up to a certain point and then stopped cooperating.
In what respect, Detective?
She came in to speak with me for an interview, and I explained to her that I did follow up on all the leads that she had given me in reference to her stating that the defendants made mention that they would burn the house down.
This gentleman?
Yes, Mr. Lopez and the defendant, they did have an alibi. I checked that. They were already moved out of Ms. Perkins' residence. They were moving into their new apartment that whole weekend, and I spoke with family members about that. None of the neighbors saw the defendant or Mr. Lopez in the area. The only people that they did see was Ms. Perkins and her daughter. There was no forced entry into the residence.
But you had insufficient evidence, I assume, to charge anyone for the arson.
Yes, ma'am.
Is it still being investigated?
It is suspended to this time unless more evidence comes forth. Ms. Perkins originally stated that she would take a polygraph. She brought that up to me. When one was set up, she declined to speak with me any further and obtained an attorney.
And the defendant?
The defendants were very cooperative. They advised me that they would if Ms. Perkins would take a polygraph, which at that time I deemed was fair.
Okay. Yes.
I declined because I went in his office and he talked to me and he sat there and told me that his opinion was that I either started the fire or paid somebody to do it. And I got up from there and went straight to my lawyer, Homolides. And Homolides says, do not take a polygraph test. It doesn't show anything at all. We've been trying to get him, the police, and everybody to take fingerprints off the kerosene can. They've got a picture of it in here that has not been moved. Fingerprints help a case, not lie detector test. He would not do it.
There were numerous fire personnel inside the residence at the time of the fire, and it was handled.
Well, it can be handled, Detective, but certainly there would have been no basis for either the defendant's prints or her boyfriend's prints to be on that can.
From what I understand, that can had been there previously to the fire.
Not when they were living there.
No.
Because
No.
according to Ms. Perkins, according to her complaint, she purchased some things, including this gasoline, left it in the bathtub after the defendant moved out. And even the defendant, unbeknownst to you, but they shook their head no, because you said the can was there. They acknowledged that the can was not there when they were living there. So that certainly, forensically, would seem to me, listen, that's not my field of expertise, but I watch enough CSI to know that that kind of forensic examination is something that would be reasonable and admissible. Not only reasonable, but admissible. So if their fingerprints are on it, a bell would go off in your head because it wasn't there when they were living there. So either the stork would have brought their prints to this can, or it was there as a result of their being there prior to the arson.
Yes, ma'am.
It's still there.
It's still there. It's still locked up. Same place.
Still there, still locked up. So why don't we go get it?
Judge Judy continues in a moment.
She had like on
Just a
the
second.
arson,
Just a
she
second.
had on.
Just a second. Do you want to say something to me?
Yes.
Can you look as if you're interested
Yes.
and sit up?
Yes.
Good.
And later today,
Eventually I told him, listen, just stop.
real cases, real people. Judge Judy. Mary Perkins says former tenant Ashley Hoskins owes for rent and for damaging her home. Ashley is countersuing for harassment.
Now, so far, Ms. Perkins, the defendant owes you $515 for rent. She's not going to give you any money for damaging the house because I'm not going to make a judgment with regard to this arson because of my lack of evidence as to who started this fire. If he doesn't know who started the fire...
I have a witness. It's not here, but I do have a...
If you have a witness, bring the witness to the detective. That has nothing to do with me.
I have called and told him all about it, and he just ignores it. And I also called the insurance company and told them all about it. They were very interested.
You have given that name to him?
Yes, I have.
Okay, and you have or have not interviewed that witness?
I just received that information before I came here.
Well, then I'm sure you'll be doing that right
Yes,
after
ma'am.
you get the can examined by your own forensic unit. Okay. Now, Ms. Perkins, so listen to me carefully. $515 is what she owes you for rent. Now, Ms. Hoskins, you have a counterclaim, and your counterclaim is for...
Ma'am.
Do you want to tell me what that harassment was, Detective? You may be seated. Thank you for coming.
Yes, ma'am. There's numerous times that she came over and harassed me. She got her grandson to break into both of my vehicles. And
I want you to be quiet.
I have the court papers saying that he pled guilty and...
May I see it, please?
And he was living with her at the time.
Your grandson pled guilty to these charges?
Not to my knowledge. And he wasn't living with me at that time. He was living with his mother.
Okay.
Well, it doesn't make a difference where he was living. Now, it is clear that the grandson, whichever grandson this is, pled guilty to breaking into these two vehicles. Now, this is your problem, Ms. Haskins. You have to connect the dots. Connecting the dots means that you have to connect Ms. Perkins to her grandson's behavior. Do you understand?
Yes, ma'am.
Can you do that?
He lives with her.
Who cares?
It don't matter.
No, it doesn't matter. Don't matter, and it doesn't matter.
I mean, she had like on
Just
the
a second.
arson,
Just a
she
second.
had on.
Just a second. Do you want to say something to me?
Yes.
Can you look as if you're interested
Yes.
and sit up?
Yes.
Good.
Yeah. All right, she had till the 27th to fix everything in the house.
Not interested in that. Not
Okay,
interested.
but
Listen to me.
She's telling us
Listen,
we burned out
listen.
the house and we gotta sit here like this.
I don't ask you to do anything, sir. All I ask is whether you had proof that her grandson, at her request, did damage to your property. The fact that her grandson lived with her is irrelevant.
Okay.
So I'm going to ask you again. The defendant has no such proof.
Okay.
Do you?
No.
Sit.
All right.
Judgment for the plaintiff for the amount of $515. Your counterclaim's dismissed. Thank you very much.
Parties are excused. You may step out.
Her grandson was living in her garage, and he wanted us to get out, so did she, so she didn't have to have him living in her garage, and he could come and live in the apartment.
Oh, that's a lie.
This whole thing is crazy, man.
I'm getting out of the landlord. I don't care to ever rent.
All I can say is what comes around goes around, and God will handle her. God doesn't like ugly.